Yes, Your Honor. S23A0203, Brandon Williams versus the state. Devin Rafis for appellant, Dane Yulski for appellee.
Good morning, Mr. Rafis. You may proceed.
Thank you, Chief Justice Boggs, Presiding Justice Peterson. May it please the court. Good morning. My name is Devin Rafis. It's an honor to be here on behalf of Mr. Williams, the appellant, before this honorable court. I would like to share my condolences to Justice Ellington and his family. And I do want to spend my time today, and the reason I requested oral arguments, to focus on two particular issues under the ineffective assistance claims that I raised. The first being the witness issue, the missing witness, the failure to investigate, and the second being the failure to request a self-defense instruction. So getting right into it, with regards to the witness, Stanleisha Johnson, AKA Hypnotic, was a crucial self-defense witness as we heard her testimony at the motion for new trial hearing. She was not investigated. She was not called as a witness by trial counsel. However, her testimony at the MNT hearing suggested that had she been called as a witness, she would have testified to a few things. One is that the victim had a gun by the table. Two, the victim had it in his hand. Three, the victim was loading the gun with bullets. The victim was racking the slide, and eventually the victim pointed the gun in the direction of her and appellant that were standing beside each other. So the reason I raised that issue is trial counsel failed to investigate because there was additional testimony from Rodney Farrell, which is the appellant's father, and also the mother of appellant's children, Jasmine Jones, that testified they had actually found Hypnotic. She was listed in the discovery. She was there at the scene. They had found her. They had went to her house or apartment, whatever it was, her residence. They had got her contact information, and they provided that to trial counsel.
So is it your basic contention that the reason this was so important is that her testimony would have supported a self-defense defense?
It would have advanced that theory of defense that was already being presented at the trial. However, had this witness been there, it would have been even more crucial. It would have further advanced that argument.
So you said something important. You said it was already brought up at trial. That goes partially to another one of your enumerations, right, about whether there was slight evidence of self-defense.
That's correct.
What else was there that would have established at least slight evidence of self-defense?
That was presented at the trial?
That was presented at trial.
There were a few facts, Your Honor. You have, one, the victim had a gun. I think that came out through a bunch of witnesses. Andre Reese said that he gave bullets to the victim. The victim had a gun, and he placed the gun on the table right in front of him where him and his friends were.
Now, up to that point, that really doesn't support self-defense.
It's leading up to it, you're right. I mean, it's a fact that goes to it.
It's the backdrop. But was there any witness that testified that they saw this gentleman rack the gun in front of your client, point a gun at your client, anything like that?
There was not a witness that specifically said, I saw the victim point the gun at appellant, at Brandon Williams or Stanleisha Johnson, or anyone. However, there was two witnesses. The first was Vernice Beard, said that the shooting only happened after the victim pulled the gun out, and actually Beard even said, don't point the gun this way. And that's transcript page 497. Rufus Hammonds is another witness that would have been slight evidence in and of itself, I believe. He said there was a struggle, and after the struggle, there was gunshots.
So, I mean, it does seem like that would support slight evidence. Slight evidence is slight. On the flip side, that doesn't help your IAC claim all that much, right? Because to some extent, that means any additional testimony about self-defense would have been cumulative of whatever else had been admitted already at trial. Do you see those two things kind of being in tension with each other?
I think that, if I understand Your Honor's question correctly, I think that the missing witness, Hypnotic, would have created that, I don't know if I want to call it a missing link, or if it would have been that extra step that absolutely would have gotten self-defense there as far as he racked the slide and pointed the gun at us.
Look, if you have slight evidence, you're supposed to get the instruction. Maybe it's harmless error, but you're supposed to get the instruction. So for you to prevail on the missing witness, you have to show that her testimony was so important, that the trial counsel was objectively unreasonable and that it would have changed the outcome of the trial. What I'm trying to figure out is, would her testimony, even if it were more clearly in support of a self-defense defense, would it have really changed the outcome of the trial if you have a bunch of witnesses who say, look, the guy was just sitting at the table, gun was on the table, but he didn't touch it, and then a couple witnesses who said, there's a struggle, there's a fight, which would have supported an instruction, but maybe, then you just have a bunch of people conflicting with each other.
I think the answer to that question is yes. The victim's friends that were standing beside the table, and I'll put up a state's exhibit just to pull up a demonstrative for the court. This is the table where the victims and the victim's friends were standing. The victim would have been to the right of the table, closer to that Powerade bottle, and the rest of the friends were allegedly on this side of the table. And so the victim's friends are the ones who all say that he never pointed the gun directly or even fired a shot, which I think it's not contested. But the thing it would have went to is credibility, because the other witnesses that weren't victim's friends all said some different stories. And so the reason Hypnotic would have been so important is because her testimony at the motion for new trial hearing actually corroborates some of the ballistics evidence, which is why I have a problem with the judge's order, or shall I say the state's order that was submitted to the judge and sort of rubber stamped by the judge's signature. The order says that the evidence that was presented at the motion for new trial hearing would have contradicted and sort of is not prejudicial because it doesn't match up with the ballistics, that being the victim was allegedly shot in the back. However, if you look at the evidence, let me pull up the, you can see from this, one of the autopsy photos, this is the victim's head, this is the lower area, this is to the left of his middle area, his back is right here. So if you're looking at that, he's got shot in the left side. If you take all the testimony as true, and even Hypnotic's testimony that he was standing right here racking the slide and that he was facing forward, and that, pull up one other picture to give a little bit of background.
Do you think we need the picture?
I'm sorry?
Do you think we need the picture? We're happy to look at it, but I mean, is it going to support the legal argument?
It will. So if Hypnotic's testimony says that Brandon Williams came through the door, which is back here, and that the victim then racked the slide and pointed it at them, he's still facing forward. And if Brandon Williams' appellant then fired in self-defense, it would have absolutely hit where it's to the left of his torso. So it still matches up with the ballistics. So I think the trial court's reasoning was erroneous, the factual findings was erroneous, and that there was prejudice in not getting this witness there.
Mr. Rafis, sort of regardless of what additional help this missing witness could have provided to self-defense, didn't the trial court reason that, I think that counsel testified that Williams had told her that he wasn't present and that they had this sort of different defense than self-defense, and so strategically didn't want to introduce this because it would actually conflict with that defense, that he wasn't there. We generally give great weight to strategic decisions in this analysis. Why isn't that enough on its own, sort of putting aside all of these pieces to reject the ineffective assistance claim?
Thank you, Justice. I don't believe there was ever a response from trial counsel at the MNC hearing that it was a strategic choice not to put up or even investigate Hypnotic.
But that was the trial court's reasoning, that it could have been strategic because it would have conflicted, right? Is that not?
Right, so I have a couple of issues with that reasoning. One is the trial court is essentially saying, hey, we've heard from Hypnotic now, but still it would have contradicted what trial counsel was presenting earlier on. However, trial counsel didn't know what Hypnotic would have said. No one reached out to Hypnotic. The first attorney.
I'm sorry, but what weight do we give that? Because she said that she didn't get the information to even reach out to Hypnotic. So, and the trial court relied upon that. So are you saying that we should discount what she said in the trial court's finding as to her reliability?
I think the trial court's finding is a little erroneous. Like I said, you do have to give deference.
That's a new standard for us, a little erroneous.
A little erroneous. It's clearly erroneous. My apologies for misquoting. But yes, so there's other issues as far as that goes. Is if the motion for new trial hearing testimony from trial counsel was, yes, appellant's family did give me information on Hypnotic. That's page 21 of the MNC hearing transcript. Then why wasn't a request form filled out? So in the PD's office, if there's something that needs to be investigated, the transcript says that the attorney would fill out saying, hey, I need you to find Hypnotic for this case. There was nothing in the file that suggested that a request was ever filled out. The question is why? Because if information was given.
Unfortunately, I think the question really is that outside the norm of what an objectively reasonable lawyer would do? And if it's not, there could be a bunch of things that could have been done better or different strategic choices that could have been made. I think that's what, and this is a difficult argument to succeed on every time, right? IAC necessarily is a difficult burden. I want to tell you one of the things that did catch my attention, and I'm sure I'll ask your brother across the way when he gets up, but I think you have an interesting cumulative error argument. I don't know how it all shakes out, but it does seem like the state kind of individually looks at each of the errors that you allege and just kind of waves a hand and says, well, maybe it was error, but if it was harmless. But they say that a bunch of times. So can you walk us through what that cumulative error analysis would look like and how you would aggregate potentially different kinds of errors, some evidentiary, some IAC?
Yes, Judge. I think that I agree with the reasoning there. I think that there's a lot of harmless, but again, we look at it all together. And a lot of them flow together, like the self-defense instruction and the missing witness that would even help further that instruction. A lot of them flow together, and so when you look at them all together, I think that, I mean, look, this guy's facing a murder charge, right? The only thing he's asking for is for a fair trial, a fair shake at it.
Well, and Mr. Rafis, you say they all flow together, and I think that's what I'm interested in too. Is there sort of a picture or story that sort of ties these together that in a way, if sort of you look at them individually, they are harmless, but if you sort of paint the picture together, there's some sort of, that it crosses that line?
I think individually, the harmless error standard may get there on a few, but I think specifically with the self-defense instruction and failing to request it, and also the missing witness, I think those two are key in this case, because had both of them been done, I think the outcome, there's a reasonable probability it'd be different. Because there's already evidence out there, and it's advanced pretty heavily in closing argument as to self-defense. There are a couple shots that were taken on cross-examination of some witnesses about identification or him not being there or something to that effect, but I think those were just freebies in the trial. The majority of the closing argument and everything advanced was dealing with self-defense. So why wasn't it requested? No reasonable.
How strong is your cumulative argument if self-defense is out?
If the self-defense instruction is out and the missing witness situation is out.
Either because we find it was correct for the court to find it was a reasonable strategic decision, or because it was harmless.
And I think if you look at all the other errors, taken together as a whole, do I think he received a fair trial cumulatively? I would say no.
Well, I appreciate that. I want to know what you think about Lane and what you think about cumulative error and how they're all tied together. And so I think the question that Justice Warren asked earlier is, can you walk us through each element of those cumulative errors, alleged cumulative errors?
If I remember Lane correctly, Your Honor, that dealt with mainly a trial court error.
Well, so Lane, pre-Lane, we had always cumulated error in IAC because that's federal law and that's what the U.S. Supreme Court said too. But pre-Lane, trial court error we would only consider in a silo. Each error was either harmless or harmful on its own. Post-Lane, we've said that doesn't make any sense. The state agreed it didn't make any sense. And what we do is errors that are of a sort that you actually can combine them such that their harms have interactive effects or build on each other. We put it all together, whereas errors that are just not logically or rationally related don't get accumulated. So all of the various errors that you've raised, at the end of the day, you're going to want us to do a cumulative error assessment of every error that we either conclude was error or presume was error. And we need your help in figuring out what is the harm that flows from each of the errors and how do those various harms sort of build on each other to get to kind of cross the harmless bar.
Yes, Your Honor. I think the harm, let's just take the self-defense issue out of the picture and we just look at a
Try the tattoos. Let's talk about the tattoos.
Okay.
So those are two errors that seem like they dovetail together, right? Because you're alleging on one hand that the trial court should have let your client show his left arm to show whether or not he had a tattoo because somebody said they saw a tattoo on the shooter's arm. And then also you allege that there was an error in effective assistance of counsel because trial counsel didn't enter the booking photos because surely a booking photo would have chronicled all the tattoos on a person who's going to jail. So walk through, how strong those arguments are to show us whether those are things that really might have been error, including things like, do you know if your guy actually has a tattoo on his left arm? What would a photo have shown? Is that too speculative? Things like that.
Yeah, at the motion for new trial hearing, Mr. Williams, the appellant, did testify, and that was one of the things is that I asked him to show his left arm. There were clearly no tattoos, which is different than a lot of the cases that we have, which you're usually trying to have someone say that, maybe I got the tattoo later or something versus having it removed. And when you have it removed, you can't ever get it fully removed. There's always going to be some sort of leftovers there. I don't know the word I'm looking for, but so he did testify to that, and the trial court looked at it.
Residual harm.
Right, there you go. And so I think it was error, and there wasn't a need for him to be cross-examined or anything like that, because I'm not asking for him to take the stand and show it at the trial. It's just, hey, it's sort of like if a witness says it's 2 o'clock and you have a clock in the courtroom and say, doesn't that clock say 3 o'clock? It's sort of the same thing, I
It
think.
is a little different when it is the defendant, right? And you're dealing with issues of self-incrimination and opening the door and waiver. So I don't think it's like any other witness. And I think that's your colleague's argument on the other side, right?
His argument is that there needs to be a foundation laid, is the main argument I think they're pushing.
And also no right to cross-examine, correct?
And the right to cross-examine, which I think they focus less heavily on, they rely more on the foundation issue, but yes, both. But again, the foundation issue is not there because a lot of the cases, like I said, the foundation issues are whether or not you eventually got a tattoo later between the incident and the time of the trial, but we have the inverse.
But so even if there is error on the tattoo issue, it doesn't seem to me, I mean, tell me if I'm wrong, that the tattoo issue and the self-defense issue really augment each other for purposes of harmless error, right? The tattoo issue is sort of an argument that he wasn't the guy. The self-defense issue is that he was the guy and he shot in self-defense. So I don't see that those combine to create a greater harm under Lane. Is that wrong?
You have a point, but the point I think of the tattoo cross-examination would have dealt with showing the credibility issues of the victim's friend. Because again, most of the argument at closing dealt with the self-defense. I think that the pushing of the tattoo issue and the inconsistent statements there with the victim's friend, I think that just would have went to the credibility issues that could have been further argued. It was already argued a little bit on closing. It could have been further argued. And so when we go back to the jury instruction issue, that's paragraph 9 of the judge's order. The order said that the evidence was only slight or none at all. But if the judge is acknowledging that there's only slight evidence, I mean, that's all that's needed. So I didn't understand that part of the order. The facts at trial, as I said, you have multiple witnesses that said there was a gun, that there was a gun being loaded, that someone said, don't point this gun this way, that there was a struggle, an argument, and then shots were happening. So all of that evidence is out there. Absolutely, the self-defense instruction should have been requested. And trial counsel admitted that the request should have been given and at the motion for new trial hearing, and that it wasn't a strategic choice not to do it. She said she absolutely should have done it. And so I'm going to reserve.
Does that really matter? I mean, it's an objective standard, right?
It is. I mean, it goes to something that the court should consider, the fact that the attorney said that it wasn't strategic. But yes, I mean, you do look at other things. It's an objective standard, not subjective. But it is something you look at. So I'd like to reserve the rest of my time, if that's okay.
Thank you, Mr. Revis. Mr. Uleski, ready when you are.
May it please the court, my name is Dane Uhelski. I'll be arguing on behalf of the state as appellee in this matter. As you all are aware, we're asking that the court affirm the trial court's denial of appellant's motion for new trial. Let's start with the first enumeration of error, the tattoo. To display the presence or absence of a tattoo on a non-testifying defendant's left arm is absolutely going to open the door to cross-examination. Our position is that is testimonial. It's an assertion that's intended as a statement of fact, which is
No, your position is that it's not testimonial, but under the Georgia Constitution, it's an affirmative act that's still protected, right?
That's correct, under Georgia's rules, correct. Even aside from whether it's testimonial, if it's a demonstrative, it still needs a foundation. We don't have Detective Otts, the lead detective in this case, we don't have him on the stand able to say, yeah, that's the exact way this man's left arm looked 8 years prior to trial. There's no way that they could have laid a foundation for that statement or for any booking photographs. Detective Otts, he wouldn't have had access to a booking photograph that showed what appellant's left arm looked like at the time of the incident. And more importantly than all of that is the harm analysis, which I think your honors were interested in. This was a tangential aspect of one of three positive and unwavering identifications of appellant as present at the scene as the shooter. Shenard Shears told Detective Otts 8 years before trial.
I mean, I'm not sure I totally agree with where you're going, because the jury's authorized to believe or disbelieve anybody that testifies. And so, you know, in the state's view, you have 3 people who say certain things, and it all supports your theory of the case. But if one of those people says the guy who shot has a tattoo on his left arm, it seems like the defendant would have a pretty strong interest, if he doesn't have a tattoo on his left arm, in saying, you know, let me show you my arm. But more importantly, I mean, I'll tell you the same thing that I told your brother across the way, which is, it does seem like the state has treated all of these alleged errors in the kind of silo that Justice Peterson was talking about, the kind of silo that we don't allow to happen anymore under Lane if errors are found or assumed. So I think the state has a lot of work to do to show not just that things maybe were an error, we can just assume it and say it's harmless, but to show why they were not error. So can you do some of that work for us? I don't think your brief quite does that.
So for the tattoo issue, just in relation to the cumulative argument, which is the tattoo goes to one of the eyewitnesses' identifications, it was a very...
Why did the trial court, why did it not abuse its discretion in saying, no, you can't show it?
There wasn't an appropriate foundation laid that would have allowed the jury to kind of have...
Was the defense offered the opportunity to lay that foundation before the trial court concluded that the defendant couldn't show his arm?
I don't know that they went that far. I don't know that it got that far. But this identification testimony, you know, whether or not the person had that tattoo, that wasn't testified to by any of the eyewitnesses. That was testified
Let me ask
to.
you, what kind of foundation are you asking for? Because I'm thinking in the reverse case, a lot of times the state wants to prove, say in a gang case, that there were tattoos showing that the defendant was in a gang. And sometimes those tattoos are on the face and you can just clearly see it. So are you saying that the state cannot have someone testify about tattoos on someone's face because that is some sort of protected testimony? Because it goes both ways.
Well, in answer to your question, it's not protected in any special sense. It's just an affirmative act that would have required, you know, a volitional choice to, you know, roll up the arm and display it to the jury. Appellant's argument is that it was just a matter of asking the detective, do you see a tattoo on the gentleman's left arm?
But the Georgia right against compelled self-incrimination only prevents compelled self-incrimination, and here he actually wanted to do it.
Well, I mean, that argument is kind of like the converse of one. It's like kind of the contrapositive, I guess you would say. If in Georgia law you can't compel somebody to, you know, display a tattoo on their, say, torso under Boynton, then by the same token, if you're going to allow someone to, without testifying, subjecting themselves to limited cross-examination, no foundation whatsoever, then the state's position is that would follow from that, you know, displaying a tattoo would be a statement.
Help me understand. We talk about no foundation. What foundation is needed to observe the physical traits of a person's body that's present in front of you? I mean, either this person, I understand that you might have, because of the passage of time, other arguments to make about that, but explain, I'm not following the foundational piece of that.
Well, the jury has nothing that's going to allow them to say, like, this, the way this arm looks, you know,
That's
to
not
you
the point.
now.
The point
That's
was
not-
not that there was a unicorn tattoo and you're trying to match the two unicorns.
The
Right?
question
The point
is
is there a tattoo or is there not a tattoo?
Okay.
The question is, how does the arm look today, right? And how it looks today, at least is in some way probative of how it might have looked before, right?
Right.
There may be arguments for that why it would change, but those are arguments. Those don't change the nature of what it is.
Aren't you really getting at the fact that the state would not be allowed to cross-examine, to ask the probative questions regarding, you know, what his arm may have looked like on the day of the incident?
If he's allowed to show the jury without any kind of taking the stand or any, the state wouldn't have been able to test that
But you
fact
didn't
in
get
any
there
way.
because the trial court said he couldn't do it.
That's correct, and it really just leads into the harm analysis. It really,
Right, but I mean, there are a lot of alleged errors in this case, and the state, in almost all of them, just says, maybe it was an error, it was harmless. that leaves you with a serious Lane cumulative and error analysis that I'm not sure the state has fully comprehended, and that might not go well if you can't actually show that some of those just simply were not an abuse of discretion or were not an error of law, instead of just assuming the error and saying it didn't matter. And that's the work we're asking you to do here to help guide the way.
Well, okay, just going into the harm with the tattoo, it's not
We don't
something
want
that,
the harm with the tattoo. We want to know if the trial court made an error of law in saying, no, you can't show your arm.
our position is that the court was correct and that the court didn't abuse its discretion in declining to allow the appellant to sort of testify without testifying, without foundation.
But how can that be really the case? I mean, if it just happened that the defendant was wearing a long-sleeve shirt that day in court. I mean, if he was wearing a short-sleeve shirt, couldn't the cross-examination of the investigator have asked, is there a tattoo on his left arm? I mean, he's just sitting there with a short-sleeve shirt on. I mean, so what's the difference in those two scenarios?
Well, it doesn't say what this gentleman's arm looked like at the time. It needs to be a true and accurate
But
depiction.
so you're saying that that question cannot be asked of the investigator on the stand if he's sitting there with a short-sleeve shirt on? Like, I mean, what does he have on his arm at the time?
Well, let's, assuming for the sake of argument, he doesn't have a tattoo, right? There's really, that's not evidence that he didn't have a tattoo at the time the identification
sure.
was
Of
supposedly
Of course it
made.
is. Of course it's not conclusive evidence, but of course it's evidence that he didn't have it at the time. Right?
Well, I mean, it is possible that he could have had one, but it was just a tangential aspect of one of the witnesses.
That's a harm argument. That's not an argument about whether the trial court abuses discretion in deciding whether to admit or not allow evidence. You want to try, let's move to another one.
Yeah.
Okay, so
What is the best of all the contentions that the appellants have brought today? Which of those alleged errors can you most easily debunk, not based on harmless error, but based on an argument that the trial court did not abuse whatever legal standard is applicable to that alleged error?
well, I guess that would bring me to the self-defense instruction. There was allegedly some evidence of self-defense, but the state's position is
So
that.
wait, what does it mean for this is a tough argument for you. If there is slight evidence, even if you think the person who said it is not credible, even if you have 15 different arguments about why it's bad testimony or inaccurate, or the person, is a known liar, that's slight evidence for a jury charge.
Well,
Is that the law in Georgia?
under the rules of this court,
What's the law in Georgia? What is the legal standard for being able to ask and obtain a jury charge?
right, for trial counsel to request one, slight evidence is needed. That's correct.
And the trial court on this issue said only slight or no evidence were present on this, right?
That's correct. That was in
Isn't
the
that
trial court.
application of the wrong legal standard? Because the presence of slight evidence does require the charge.
Well, sua sponte for the court to give it, that needs to be the only defense that's raised. And there were multiple defenses.
Different issue.
Okay, so we're on the
Judge
high-
says there wasn't enough evidence to give this charge. But the judge says there was only slight evidence or no evidence.
Okay,
But slight evidence does warrant giving the charge. So why didn't the trial court apply the wrong legal standard in determining that there was not sufficient evidence to give the charge?
well, trial counsel, if there was slight evidence, has the ability to ask for it, but that's a matter of strategy, right?
Okay, so maybe I'm missing something. Did the trial counsel not ask for an instruction on self-defense, or did trial counsel ask for an instruction on self-defense?
Trial counsel did not.
Okay, so that's the layer that you're putting over the argument, right? So
Right.
are we doing a plain error analysis?
When it comes to the trial counsel's decision not to ask for self-defense,
I think
The error
you
in
might be going into that. I think there's an IAC claim on it, but I think there's also, and tell me if I'm not right, but I think there's an enumeration that there should have been an instruction given.
that is
Separate from
correct.
an effective
So,
assistance.
and
Yes,
plain error
separate from
applies to
that.
that because there wasn't an objection. And part of the plain error standard is that there is an error that was clear and obvious. Under Georgia law, it is clear and obvious error to say there is slight evidence to support this jury charge, but that is insufficient to give the charge. That is clear and obvious error. So why isn't the order from the judge saying there was only slight evidence or no evidence to support this charge, therefore I'm not giving it? Why isn't that clear and obvious error?
Well, again, if there's more than one defense, the court's not required on its own to give an unrequested
That is not a
charge.
response to the question I just asked. The judge gave the reason for excluding it as there being insufficient evidence to support the charge, right?
That was the
And the
order.
judge said there was only slight evidence or no evidence to support it.
Correct.
That is wrong as a matter of law. Slight evidence does entitle you to a charge. So the judge applied the wrong legal standard, correct?
In the decision of the trial court not to give the instruction, there's two pieces. One is whether they should have given it unrequested, okay? And then the other was, was it error for trial counsel not to have requested it? So if there is slight evidence, then trial counsel has the ability to request it, and in that event, which didn't occur, then, slight evidence gives you the instruction. But the problem with that instruction, again, is you have trial counsel testifying that the leading theory of the defense was presence at the scene. Person wasn't there.
But what about the
Self-defense
fact-
contradicts that.
What about the fact she says she should have asked for the self-defense charge?
I think that would be hindsight, and part of that was that throughout the trial, you have your
I mean,
written request.
objectively speaking, there are all these witnesses who place the defendant at the scene, and then you've got all these witnesses, well, you've got Vernice Beard saying, B started shooting right after Coleman pulled his gun out. That seems to me more than slight evidence of possible self-defense. So the question is, I'll go back to the presiding justice's question, why isn't that clear and obvious error under the plain error standard?
Well, the state's position is that wouldn't have been slight evidence. To have a gun sitting in front of you on a table.
That is completely the opposite position that the trial court made. The problem for you here is the trial court went to the trouble of saying what they said, which was, there is slight evidence of this, but I'm still not giving the charge. Had the trial court not said that, maybe any other number of arguments for you might have worked. But when a trial judge says there's slight evidence and then doesn't give the charge, whether asked for or not, that is clear and obvious error, is it not, under Georgia law?
I believe the trial court's only required to give it if it's the sole defense in an unrequested situation.
So I think there's a gloss that you're missing, which is sometimes trial courts, we presume that trial courts know and apply the law unless they give us a reason to think or know otherwise. So if a trial court had just seen the evidence, not said anything, decided not on his own to give the instruction, that's one set of arguments. That's not what happened here. I think what happened here is saw the evidence, and then the trial court said affirmatively there was slight evidence of self-defense. And at the moment the trial court said that, if the trial court then does not give the instruction that is required under Georgia law for slight evidence, that's the error. Do you see what I'm saying now?
I do.
Yeah.
My answer to that question is the trial court at the time of the trial never said there was slight evidence. The trial court, in its order denying the motion for new trial, much later said there was either slight evidence or no evidence at all. The state's position here today is that there was no evidence at all. The struggle that was mentioned from Rufus Hammonds, that was something that was pointedly put on cross-examination. Did you see a struggle? Mr. Hammond says, I'm not sure what you're talking about. He says there may be
So do you disagree with the trial court's factual finding that there may have been slight evidence to support the charge? I mean, we generally afford very substantial deference to factual findings of trial courts.
I'll allow that the trial court said there was a disjunctive statement that says there was either slight evidence or no evidence at all.
Which is another way of saying there may have been slight evidence.
Right, that there may have been, there also may not have been. It's kind of an interesting proposition when you look at it much later after the fact. But there being possibly slight evidence doesn't change the fact that trial counsel didn't request it, and that's a matter of strategy.
That's why we look at it through the lens of plain error. But it is indisputably, as a matter of state law, clear and obvious error to fail to say there is slight evidence and refuse to give an instruction.
That clear and obvious error might otherwise fail the plain error test, but that's the first prong, right?
Okay, yes.
The challenge is it could be harmless, which would be your better argument, but we're talking about cumulative error now, and so we're picking apart each piece. You understand?
And putting the pieces together with sort of the accumulation argument. You have the accumulation of this problem with the identification to do with the tattoo. That's not going to accumulate, that's not going to aggregate with an argument that there's harm to do with a self-defense instruction, because those are
Your friend on the other
antagonistic.
side responds that it at least goes to the credibility of the witnesses, which would accumulate, I guess, to some degree with that, right? In other words, it was not credible, and so could help the self-defense argument, sort of in that sense.
I get, yeah, if you're arguing the credibility of, Shenard Shears, what he told the detective, 8 years prior to trial, that goes to a sort of an aspect, a minor aspect of one of the identifications.
But as a general matter, so it could sort of marginally accumulate with the self-defense piece. Not in the way that that goes to sort of ultimately what happened, but to credibility as a general matter.
I would say that it doesn't aggregate in a meaningful way, just because on principle, the two arguments from harm are kind of coming from antagonistic points of view. You have one that's to do with the credibility, to whether he was identified correctly at the scene, whether he was there, presence, which was the leading theory. And then you have another argument that's about, well, this blows that first one out of the water because this one puts him right at the scene. So for them to accumulate, my position is that they would be more likely to cancel out other than that credibility.
Here's a question I truly don't know the answer to, so sorry. But we talk about the idea of accumulating on credibility of witnesses. But can you consider an accumulative error analysis, for example, well, if the trial court hadn't made this error, then the jury could have picked this theory that could have acquitted the defendant. And if the trial court hadn't made this error, then the jury could have had this other theory that would potentially acquit the defendant. And just because there are multiple theories that the jury did not have access to at the time, that had those errors not been made, they would have had access to, can that be the potential change in outcome required for a cumulative error argument to succeed? I hope that made sense.
Okay, so.
And I'll give you a contrast. A different contrast would be one error got so magnified that all of a sudden that one error itself could have tipped the jury the other way.
Sure.
So what I'm asking is if different theories, he wasn't there, this witness wasn't credible, and then some other theory, by giving the jury access to those theories, could that have changed the outcome?
I mean, I think that there is a much greater tendency of one potential error to be magnified, underlain in terms of another when it goes to the same theory of the defense, which would be, if you had an identification issue with the tattoo and then you had a failure to request maybe an identification instruction, then those very obviously are going to be cumulative, and you're going to have those building up to the point where you have maybe either one's not its own, unit of harm that's cognizable, but added together, you have multiple problems that add up to this wasn't a fair trial. Our position is that this absolutely was a fair trial, and that these problems with the identification, problems with self-defense instruction, because they're antagonistic, they don't have that same tendency to magnify. I hope that answers your question. I'll cede the rest of my time if
Thank you, Councilman.
it pleases the court. Thank you.
Mr. Raffis, you have a little over 2 minutes.
Thank you, Chief Justice. I just want to go over some of the errors here. I'm going to look at a total of 5. When appellant was not allowed to show his left arm, that dealt with credibility. It dealt with him not being their defense and going towards that at closing. The reason I'm going to talk about these is because it deals with the cumulative effect, and also whether or not the failure of the trial court had a substantial effect on his rights after the clear and obvious error. Second, trial court erred when it allowed hearsay from Priscilla Fambro. That's the lineup identification that she was not there to testify about, but was allowed to talk about anyway through the detective. That dealt with credibility, confrontation issues, a lot of stuff going there towards also him not being present. Because remember that the only eyewitnesses that sort of testified was the victim's friends that were at the table. The same friends that stashed the gun, hid it, and sold it later, which seemed a little suspicious if it was just a straight, I got shot. Next is trial counsel ineffective assistance for failing to admit a booking photograph to show, again, that there was no tattoo. whether that's booking photograph, whether that's calling the father as a witness to say, no, he's never had a tattoo on his left arm. Failing to conduct a thorough investigation, this goes to Hypnotic, goes to, after all of this errors going on, I think it's even more important that Hypnotic should have been called to put that missing piece as far as pointing the gun at us, which is why appellant shot first. And then failing to request a self-defense jury charge, I think that's, to me, in my mind, that's obvious. If you're floating the idea and pushing hard on self-defense, on cross, and then at closing, how is it not reasonable to then request that the charge be given so the jury knows how to deliberate? And so when you look at all those together, I think that there absolutely is cumulative error. There wasn't a fair trial when you
Seems to me
compound
the
all of it.
first three of those go to the issue of his presence, and the last two don't. Is that fair?
I'm sorry, Chief Justice, I didn't hear the first
three
part.
of those tend to, on these interactive or interrelated effects of each of those alleged errors, the first three, the left arm, the hearsay, and the IAC on the booking photo, you articulated that they go to the issue of his presence.
Both the presence issue and also then just credibility on attacking the three witnesses, that being the victim's friends, who say, no, he never pointed the gun.
In the last two, IAC on no thorough investigation and the self-defense charge.
That goes straight to the self-defense, yes, Your Honor.
All right, thank you, counsel. We'll try to have you an answer as soon as possible. We thank you for being here today. We're going to take about a 5-minute break, and when we come back, Justice Warren will be presiding. Thank you.